Good evening, everybody. I hope you're all doing well. This is Jonathan, and today is the 20th, I believe, of August. Hope, again, everybody's doing well. As you can see from the background, I'm not in my normal home office. I mentioned in the comments, I'm on the Florida Panhandle on vacation with my family, and obviously, I want to do the live stream every week when I can, so here I am. Please let me know in the comments if the video or the audio is not good. The wireless or the internet connection here is a little slower than what I'm used to, and when you're doing video and audio, sometimes it will that will show. So hopefully that won't be a problem, but if it is, please let me know. All right, so let's kind of dive into the comments here. We have Ron Kimbrough says his stepdaughter applied online for SSDI and it showed she has only 31 work credits. It stated below that if she applied now, she would get a certain amount. She was almost 30 years old, seeing a psychiatrist for depression, anxiety. What are the chances of approval in Texas? Well, first of all, just a couple of points that you made here is most of the time you hear people talking about when you get on disability, you have had to have worked for 5 out of the last 10 years. When you're younger, when you're 30, it may be 3 out of 6 or 4 out of 7. So you don't have, or 4 out of 8 rather. So you don't necessarily have to have worked for 5 years. So it looks like your stepdaughter is insured for disability, which is a good thing. And of course, it told you what she would get. Assuming she didn't have real high earnings, it's probably not a ton, but again, if she can't work, it's better than not having anything. I would tell you that generally speaking, depression, anxiety, PTSD are difficult cases in the best of circumstances, even people who are over 50, over 55. And that's because they're invisible illnesses. Social Security, you cannot take an MRI, look at an MRI of your brain and see that there's problems with depression or anxiety. They can't do blood tests to see what's going on. So it's really going to come down to what her treating psychiatrists and psychologists are telling you or putting on the record that explains why she would not be able to work. Now, sometimes, because it's what they call non-exertional, it's not about physical limitations. It doesn't really matter as much if somebody's a little bit younger, because you can have significant mental health problems in your late 20s and your 30s, as obviously it looks like your stepdaughter has had. Still, though, it's an uphill battle. I think every mental health case is an uphill battle. I think what you need would be really strong support from treating psychiatrist or psychologist. If you can get a functional capacity evaluation form done, that would be very, very helpful. If she has school records that showed that she was having problems back when she was in school, that could be helpful. Statements from former coworkers or supervisors, that could be helpful. I think, anything you can get. I mean, if you have even statements from, people that she knows in the community, religious clergy or just third parties, that would be helpful. Even family, although that's not going to be as useful. But I think the more evidence, both medical and non-medical, you have that really addresses the specific issues she would have working, not being able to maintain emotional stability, unexpected, uncontrollable crying spells, episodes of deep depression where she's not able to function at all, paranoia when it comes to the PTSD and anxiety, all these things that would make it impossible for her to work. So I think, it's a difficult case, not impossible, but difficult. I just think that, as you get, the younger you are, the higher the level of evidence you need to have in your file must be. And I think every mental health case is tough because, look, I mean, in Congress, there's a perception that everybody applying for disability is exaggerating or faking it. And, you look at some of the testimony or the hearings, and some of the Congress people think that mental health is particularly bad because you have to rely on what a doctor says. So I think it obviously will depend on the judge you might get, but it's winnable, but it will be definitely an uphill battle. Okay, SA. When the adjudicator is collecting medical records, if he makes a decision before large collection of files are out of the case, can he change his decision? Before the claimant, let's see here, has to appeal for recon and sees the new records. My experience has been that the adjudicators set a certain deadline to gather medical records. They request them. Whatever comes in, that's what they work with. Once they issue it, and then they send it off to a medical specialist who's going to, could be a pediatrician, or could be, I mean, it just depends on it doesn't have to be the specialist you have an orthopedic problem, it won't necessarily be an orthopedist. I've seen plenty of pediatricians in there. Typically with psychologists, it'll be a psychiatrist or psychologist. But what they do is they send it off to the medical expert or the specialist. It then comes back with a report saying this person, does not meet a listing, and it appears that there's jobs that this person could do. Then the adjudicator gets the decision out. Once it's out the door, it's out the door. I've not ever seen a situation where an adjudicator will undo the initial denial and reissue it. It goes to the recon stage, which is the same office, a different adjudicator, and presumably that new adjudicator will have access to the new medical records. But if you're asking, would the adjudicator at the initial, after the decision's mailed out the door, come back and change his or her mind? I've never seen it. I don't know that it's impossible. I've just never seen it. My sense is, with as busy as they are, once it's out the door, they just move on to the next, and they just let the next person deal with it. So I think that's probably not very likely. Christina, one of my regulars, hello from California. Christina, thank you very much, and please do share. Thank you very much. Main event is in Seattle. Never been to Seattle. I understand it's very nice. I know it rains there a lot. I've been to Washington and Oregon. Never been to. I've been not to Washington, but to Oregon, Willamette Valley in Oregon. I've never been to Seattle. I have a first cousin in Spokane, which I'd like to visit him someday, but I've never been to Seattle, but I hear it's very nice. Blue City, or Tracy, is one of my clients. The SS portal went from step 3 to step 3 federal quality review on August 14th, then back on August 19th to step 2, the morning back to step 3. What's going on here? What you've been waiting 2 years, the long and difficult journey. So what Tracy's talking about is, when you log into your My Social Security account, it will show that your file is at step 1 of the adjudication process, or step 2. And there's different definitions of what these mean. That 1, it's been assigned; 2, that the records are being gathered; 3, they're being analyzed; 4, they're being, and so forth. I don't put a lot of stock into it. I just think that, and when we talked to Tracy, one of the issues that obviously popped up is this has been 2 years. It's way too long. And so once I get access to the file, we're going to start doing some things to kind of moving it along, maybe reach out to the office manager at the adjudication office where it's been, reach out to the adjudicator herself, contact, a senator's office, just to get a decision. I mean, this is absurd it's taken this long. So Tracy, we got your back. We're working on it. And I do appreciate you retaining me. But yeah, this is crazy, definitely crazy. Wayne C. was denied at initial age 54. The denial said you have some limitations, we could still do some work. Filed as a recon, and new medical primary doctors and patients should not lift 10 pounds and ambulate, sitting, standing, and walking every 30 minutes. Okay, so, at 54, to grid out, you need to be limited to sedentary. The sedentary work is defined as standing and walking 2 hours a day total. Lifting 5 pounds frequently, 10 pounds on occasion. So if you have a limitation of 10 pounds, that is within the sedentary definition. The other question is, what is the total amount of standing and walking you can do? Well, if you have to alternate every 30 minutes, that doesn't limit you to 2 hours total. So I'm not sure that you've got enough at this point to meet the grid at age 50 to 54 and 365 days. But once you hit 55, then I think you have an argument under the grids, the 202 or light section of the grids, because then you could be found disabled even if you could do light work, which is standing and walking 6 hours. So what you have to be able to do, even if you can do that. So you can walk 6 hours, stand and walk 6 hours a day, lift 10 pounds frequently, 20 pounds on occasion. That is more than what your doctor's limited you to. So I think at 55, your case becomes a lot stronger. Now, you have gone to, I don't know if you said who you saw, was it a GP? The other thing they're going to look at is who is the doctor who saw you? What is the basis of that functional limitation? Because again, a family doctor is going to be less persuasive than an orthopedic surgeon. And I think the other question is, and if you look at the grid rules, they talk about transferability of skills. So depending on the type of work you've done in the past, do you have skills that transfer? So to meet the grids, you have to show that you are limited to either a sedentary before age 55 or a light 55 and over functional capacity. So what I'm seeing from what you wrote here, it looks like more of a light functional capacity. And then you've got to show no transferable skills. Don't know what you did in the past, whether there's any transferable skills. And if you have transferable skills, the way you get rid of them, or the way I get rid of them, is argue pain, medication side effects, things that, whatever skills you've got, let's say managing a team. Well, if you have significant medication side effects, that make it difficult to do that. If you have severe pain, that might make it difficult to focus and concentrate and do some of these skilled jobs. So I win a lot of cases using the grid rules by arguing that my client meets the grid in terms of their physical limitations, and then any transferable skills they have, I call it, would be eroded or eliminated by the non-exertional impairments such as pain, medication side effects, could be depression, something else like that. So that's the way I would approach that. But I think, at 55, your case, Wayne, becomes a good bit stronger. Let's see. Dimple Bellamy says, hello from Ohio. Hello, Dimple. How are you doing? St. Louis Grand says, what are my thoughts on a case will be before an ALJ for the third time in 2 to 3 years? The veteran's case has been expedited. AI search says such a case likely has merit. And the entity that remanded the case called out more than a couple of things in the ALJ's decision, also said the ALJ did not fully comply with the first remand. Well, I clearly think that, if you've been remanded twice back to the judge, and normally at the second remand goes to a different judge, ALJ. So I don't know if that's happened here, but let's say it's going back to the same judge. That judge has been slapped down twice now by the district court or appeals council, I'm assuming district court. I would think that maybe the message should be getting through that you need to approve this case. They wouldn't keep taking it if they didn't think it had merit. I don't think the appeals council or district court is in business just to remand on a technical violation. So hopefully the judge reads between the lines. Now, there are some judges who take the attitude like, I don't care a darn bit about what the district court or appeals council is doing. I'm going to decide the case the way I want to decide it. But my sense is that if you get denied again, then I think that I would certainly ask for another judge. But I think that the district court, it starts to become a, I'll use, excuse my French, a pissing contest, where the appeals council or district court is saying, look, enough is enough, do the right thing here. So I would agree with you that that puts you in a little bit stronger position. I would be careful about relying on AI, and believe me, I'm using AI more and more as a tool to, review medical records or to, write blog posts and come up with video ideas and things like that. I have seen many, many times what they call hallucinations, where the AI engine will, cite a rule or a policy that is no longer accurate. Recently, for example, I was doing a blog post and I was talking about, I think it was, how to win a back pain case or something like that. And the AI engine, I said, draft up a blog post, which is what it would do. And it comes back and it starts talking about the treating source rule. Well, the treating source rule, which is what it was, is it's gone now. What it was is said that under Social Security law in the past, if you have been going to a doctor on a regular basis, that doctor's records and opinion would be given controlling weight in a disability hearing. After the Eric Kahn debacle, they got rid of it. So now they can deny a case based on a non-examining doctor's analysis, which most judges won't do, but it's ridiculous they changed it. But they did. So my point is that if you didn't know that, I could have written a blog post, or even worse, made an argument in a brief that talks about the treating source rule. I'd look like an idiot because there is no more treating source rule. So my point is simply that AI can be a good place to start and give you an opinion, but don't rely on it, because it is by no means foolproof. And I just, like I said, I use it for very general, it's just a way to kind of get me thinking, because I just don't think it's ready for prime time yet. Getting better all the time. One thing that it can do is take just a boatload of medical records and summarize it. And again, even then, it's not perfect, but it gives me a place to start. And I use the ones that are private, by the way. I'm not using, Chat GPT, for example, as a free plan. Everything is public. When you start paying them, it becomes private if you set your privacy controls. Notebook LM, which is the Google version, it only uses what you give it. So you just got to be careful about that, because you don't want to be using the public Chat GPT and put your personal medical records out on the internet. That's not a good idea. So I just think that at the end of the day, AI has got a place, but we're not at prime time yet. 10 years from now, if we're having this conversation, maybe a completely different ballgame. And I suspect, by the way, that Social Security will start using AI as a way to perhaps better evaluate cases and maybe get better ones approved. I don't know, but we'll see. Kelly Bricker. Husband's claim was recently denied. Lawyers appealing, clarifying that if he takes SS at 62, has his claim approved, the amount will bump up to full retirement amount. That is exactly correct. So if he takes Social Security retirement at 62, then he wins disability, they will increase his monthly payment to what the full retirement would be. I will also tell you that the attorney's fee will be based on, before he took retirement, 25% of that figure. Then after he takes retirement, it would only be the difference between early and full. So, maybe the first part of the first, let's say, year and a half was based on his disability amount. And then the next 6 months or a year might be based on, what, say 25% of that, because that's basically the difference between early and full. So just be aware of that. Yeah, I mean, that's Social Security knows that that's what they would pay, but realize that you're not paying an attorney the full amount because you've taken retirement, and there's no attorney's fees on that. And the other thing, let me point out about taking early retirement, which I think generally speaking is not a bad idea. What you got to be careful about, or just be aware of, is if he should lose his disability case. And by the way, being in your 60s makes it a lot easier to win. Let's say if he was to go to a hearing and lose, he is grandfathered in at that early retirement. He can't come back later and say, change my mind, I'm going to take full retirement. So he's going to be stuck at that early retirement figure, if he loses his disability case. So just be aware of that, but like I said, most of the time it does kind of make sense to take it. All right, St. Louis says, I hear you loud and clear. That is good. Blue City, Tracy says it's good. Sounds and looks good. I'm not sure about the looking good, but it sounds good. Okay. Maureen Shannon says, good evening. Hello, Maureen. How are you doing? Would video help her case? I think you're talking about, we say, maybe you could clarify. I'm not sure when you say her. If you're talking about Kelly, she's talking about her husband's case. Let me just address video versus audio. There's a lot of people, I get that question a lot, or in-person hearings. You have the option right now. The default for Social Security hearings is telephone. I personally think that is the best way to go. And the reason why is that there's a lot fewer technical issues. When you do a video hearing, you got to use Microsoft Teams. And I've been to enough video hearings where something is not working. I had one the other day where they couldn't hear me. And I'm changing all the settings on my computer. And lo and behold, the problem was that the audio device, it was just in a kind of a bizarre place, and I couldn't figure out where it was. So I ended up using this. I went to a headset. But it can just be a little problematic. I think sometimes what happens with a video hearing is if, let's say, somebody's using their telephone and they're holding it and they're moving all around, judges don't like that. There can be a bit of a lag with video. And so you might find yourself talking over the judge. And really the benefit is, I mean, the judge sees you, you see the judge. There's not really any sort of connection, in my opinion. It's like an audio hearing, but it's just there happens to be a video component to it. But I don't think it gives you any huge benefit. There are some of my colleagues believe in-person hearings are better. I'm not in that camp. I think that I can see a certain situation where an in-person hearing might make sense if you have something that is visually apparent as far as your disability, although judges are not supposed to, make a decision on that. But, I'm not going to lie to you. When I don't do them, and I really haven't done but 2 or 3 in the last 4 or 5 years. But when I did them, if I had a client who was, let's say, in a wheelchair or had a really bad limp, I would purposely let my client walk in the hearing room before me so the judge could see that was what was going on. Now, of course, the judge would have to be convinced this is what the situation was, not just today, but 2 years ago, whenever the person's onset date was. And I think that maybe there are some situations, maybe some mental health cases, where it might make sense for a judge to kind of get a sense of what a person is all about in terms of the problems they're having communicating. But honestly, I've been, since COVID, since 2020, it's all been virtual, and my approval rate, or winning percentage is the highest it's ever been. So I just don't think that there's any real benefit to a live hearing or a video hearing. With live hearings, another issue is Social Security is still under the, as far as I know, under the COVID protocol, which means that they will only have literally one person at a time in the hearing office, the waiting room. So it's going to be a lot longer. And correct me if I'm wrong, I think this is still the case. It would be a lot longer to get a live hearing, because it used to be back in the day when we'd have live hearings, you'd go to a hearing office and there may be 25 people in there waiting for hearings, or maybe six, seven judges holding hearings in a day. Now it's down to one at a time and every hour and a half. So if you want a live hearing, you're going to wait a good bit more time. So for all those reasons, I'm just not a big fan of the live hearing. I don't think it gives you any benefit. And the video hearing, I just think it adds a complication. If somebody wants a video hearing, fine, we do them. I mean, I do them. I'd say 20% of my hearings are video. And it is, again, it is nice to see everybody, but in terms of results, no difference. Okay. Joe here. And Joe we've been emailing back and forth a little bit, he's, I think, doing a hearing on his own. And one of the questions I asked him was, have they sent you the CD with all the exhibits, or sent you a PDF file? Maybe that's what you're saying. They're going to send it next week, and that there's going to be potentially a medical expert in this case. And maybe they want to add that. Maybe, I mean, what Social Security, and again, just my experience, because I'm getting these things electronically, the files. And so, in the 2 weeks before a hearing, the file may be updated 3 or 4 times, or maybe a new medical expert, a new vocational witness. So I don't think they're waiting because of the medical expert. They would literally send you another CD. And, again, not very efficient, or I've heard of situations where they'll email it to you. That's actually the better way to go, if you can get it emailed to you, and have that done. And then, what I would do is, load it up into Notebook LM, and ask Notebook LM to summarize the medical. Maybe if you've got the paid version of ChatGPT, that might be a good way to use that, just to ask it, what are the best arguments for Social Security disability, and see if that gives you some starting points as far as, I know as far as a brief, or as far as arguments you might make, because it's hard to go on your own, but I understand why you have to do it. But that would be something to consider. But I don't think it's because they're waiting for the medical expert. I think they're just slow because they got too many cases and they don't have enough people. Mary Simmons, depressed and stressed out with Social Security. Mary, I feel your pain. I mean, it is so, I'd say the last couple of days, I've gotten 3 of my clients have emailed me saying, can't you do anything about this? It's the federal government. I mean, they don't have enough people. They're understaffed. I mean, I think I told y'all maybe a week or two ago, I had a case in Texas, which is one of the worst states for getting cases processed. And the case had been sitting in the pending file or the pending code for a year. Nobody had been assigned to it. So we're talking no adjudicator, no anybody for a year. And then finally the case got assigned to an adjudicator. And, I called him because I was just trying to find what's going on. And he says, I've had this case for a month. I'm trying to do everything I can to speed it up, but I got to get the medical records because it sat there in, unprocessed or whatever for a full year. That's unacceptable in my opinion, but that's where we're at. And that's why I'm telling people, if you file an initial application, you haven't heard anything in 5 or 6 months, contact your senator and say, I've been waiting for a long time to get a decision. If nothing's happening, nobody's contacting me, will you initiate a congressional inquiry? And that's what I would do. It's crazy, Mary. I'm sorry you're going through this. It's very frustrating. Denise Manson. My attorney called me a week ago and said the judge ruled in my favor for my hearing. He said if you get my letter in a couple of days, but in a week and I still not gotten your letter. Denise, it's going to come down to the judge doesn't actually write the decision. If you remember, I had a couple of weeks ago, I had Spencer Bishens on. Spencer used to be a decision writer for Social Security. And so, it has to go to the decision writer who has to listen to the audio of the hearing, go through the medical exhibit, and write up a decision using a template. And according to what Spencer tells me, it takes longer to write a favorable decision than an unfavorable decision. Judges are being observed what they're doing, and they have to make sure that they support everything they said. I've had judges in hearings say to me, before the hearing, I'm going to approve your case, but I've got to get enough on the record so we don't get remand reversed because there's not enough evidence here. So it's not that you're not going to get approved. It's just going to take a little bit longer because the decision writer has to write the decision. Now, I will tell you, I had 2 hearings last week. I think they were Tuesday. And one of them, I got a call and I about fell off my chair. It was a judge who was one of the worst approval rates around. He approved my case on the record. And then the second one was a case where Social Security had approved my client, but they changed the onset date and basically cost him 3 years of past due benefits, in my opinion, unjustifiably. So I had a hearing on that. And I got both, we were approved on both of those. Basically, the judge kind of told us we're going to get approved. So the hearing decisions came down yesterday. So basically within, I think 8 days, I had hearing decisions on 2 cases. Doesn't always happen, but it does happen. There are different ones in Georgia, ones in Florida. It just depends on how busy the writers are. But Denise, I think that you're in the home stretch. It shouldn't be a whole lot longer. But I'm glad you won. Vince, hello, Vince. All's well. Yes, I am in sunny Florida where it is about 95 degrees, very humid. It's still nice. I'm not complaining, but it is definitely a little bit humid here. So we're having a nice time, and everybody just seems to be playing a lot of tennis. Although playing early, like I have tomorrow morning at 7:30 to 9 is my tennis clay courts. But that's where we're playing tennis because it's so hot after that. It's really impossible. Took a walk on the beach and just dripping sweat. But the beach. You don't have a beach in Atlanta, so I'm not complaining too much. Dennis Pedretti, being 58, no CDR. I think that it's pretty unlikely at 58 that you would have a CDR. They just are not really inclined to do that. I just don't think. I was going to go the wrong way. I'm making myself more centered here. It's pretty unusual. You're just not their target. I mean, they want people who are younger, who are going to cost Social Security a lot more money at 58. Just don't think it's really likely. Corlil, hello, Corlil, one of my regulars. I really appreciate you visiting with us every week. RD, hello from California. California's a big state. Where in California are you, RD? That's I've been to San Francisco, I've been to San Diego, been to Los Angeles. I've been to some of the Gilroy, Been to a few places in California, middle of California, very, very diverse state. You can go from agricultural to big city, but obviously great climate. And had been actually San Diego is where the NOSCR convention is this fall. NOSCR is the National Organization of Social Security Claimants Reps. I was gonna go, but I had a lot of family stuff going on, so it just didn't work out. But I kind of was hoping to go because I really San Diego is really, really nice. The wonderful zoo there. I'm kind of an amateur photographer, so I like to go to zoos, great pictures. And I have an old college buddy who lives there. It would have been nice to catch up with him. So maybe another time, but I couldn't do it this time. It'll be interesting to hear though what's new in the Social Security world from some of my colleagues who do go, because it's a lot of changes. James Reck. I've been on permanent disability for a year. My state disability money ran out in June. I submitted the exhaustion of funds letter, but I've not heard back. It's just a function, James, of how understaffed or overworked they are. Again, this may be a situation where you have to have a person who understands what to do in that situation. I suspect that it's to not continue to offset your Social Security, and the people that had the experience to do those kind of things are to take an early retirement. So this may be a situation where you contact your U.S. senator, explain what's happened, and say, we need to get this taken care of because it's costing me money every month, and I want not only the figure corrected, but I want the missed payments or to be paid the missed payments. SA is going to a new pain clinic, 3 visits. The portal only allows you to choose subjective reason for visits. Assessments link says no assessments to view. This lack of transparency is unacceptable to you. Yeah, that is odd. I mean, normally you don't find that pain clinics are going to withhold information. You might ask the doctor why that is, and certainly Social Security should be able to get it. And this would be a situation where you want to either ask Social Security to use their resources, whether it's subpoena power or the HIT, Health Information Technology, to get that, and again, maybe you just have to be subpoenaed, but you should be able to get access to those records. I don't know why, unless there's some law that basically, because I know that pain clinics are fairly heavily regulated, just because of the issues that they have had with people going to multiple pain clinics and getting different medications, and maybe this is a way for the government to try to avoid that. But it just seems to me that is that's kind of throwing the baby out with the bathwater. You should have access to your medical records, and certainly in a Social Security case, you'll have access to the entire file. DJ Mike says, this is response to Denise, takes a couple of weeks before you receive the approval. It can't, like I said, it could be, I got one in a week, but it usually takes, I tell my clients 4 to 6 weeks to be conservative. Doesn't always take that long, but that's what I tell them. Bobby, thank you, got approved. That's excellent. That is excellent. It's always good to get that letter you got approved. It's a lot. In fact, I just got a very nice email from a husband and wife. I represented the wife in a case, and we had I think two, maybe 3 hearings, and we had a judge who wanted to basically send it out to a medical expert for review, came back against me. I requested a supplemental hearing, and the judge ultimately approved the case. We had to fight. This was a younger person. She was in, I think, her 40s, and we won, and they were very, very gracious, very nice, and wrote me a very nice review, which I really appreciated. But it's a great feeling. It's like I said, it doesn't solve every problem, but it is a nice feeling when you get approved and you have a third party recognize that your struggles are legit. How much can you earn working while on disability? Mike asks. The simple answer is there's a concept called substantial gainful activity. It changes every year. In 2025, it's $1,620 a month, $1,620 a month. So in theory, if you are earning $1,600 a month, you're under SGA and you're not working for Social Security purposes, because again, they define disability in terms of whether you have the capacity to engage in SGA level work ongoing. I would tell you that if you're applying for disability or you've been approved for disability, if you start making money that's really close to that, that's going to trigger a review. Because I think that Social Security's attitude is, if you're earning $1,600 a month, are you intentionally keeping it below that amount? How much harder would it be for you to work and get over SGA? So I think that's one point. Once you're on disability, now you do have the not trial work period program, which you didn't really ask about, but I'll tell you, they have something called trial work period, which is you have any up to 9 months in any 5-year period of time where you can earn whatever you want to earn. You can earn $1 million a month. It wouldn't change anything. The trial work period amount that triggers a trial work period, I think it was $1,160, I believe is the amount. So you use up your trial work period if you earn $1,160. So if you are making $1,000 a month ongoing, you're not going to use up your trial work period, nor are you going to be close to SGA. I think that's not a bad place to be for someone who's been approved. I would tell you that I generally tell my clients, assuming they don't care about the trial work period issue, if they're earning $1,300, maybe $1,400, that's probably not going to be enough to trigger a review. And I think that's kind of a nice sweet spot. Obviously not a lot of money, but that in combination with your disability benefit, you could theoretically survive on. Social Security I think there's a balance going on here. On one hand, they want to encourage people to go back to work. On the other hand, if you have capacity to work, they want you off disability. So I think if they started, reviewing, cutting people off because they were earning $1,000, $1,200 a month, that would discourage people from even trying to work. On the other hand, when you're earning, $1,600 a month right at SGA, that's kind of rubbing it in their face, as it were, and that might cause them to feel like they need to do a review, or at least trigger a review. So that's kind of my thought. So if you're asking me for a figure, I think $1,300, $1,400 is a good sweet spot. If you don't want to, use up your trial work period months, keep it at $1,100. All right, SA is back. This is a deal breaker to me. Would be a reason to seek a different one. You're talking about the doctor not releasing the medical records in the portal. I would ask the doctor. I just think that I just need to find out what the reason is, and maybe there's a good reason. I don't know. But if they're telling you we're not letting you see because we don't think it's good for you to see it, I would kind of agree with you. Now I will tell you, that in the day, it's like it still goes on sometimes. I've seen psychological records, more psychological than psychiatric. And psychiatric means medical doctor, psychologist is the talk therapy. I've seen records that say specifically, do not release these records to the patient because it contains the doctor's observations about the patient's behavior, or the doctor, is, in order to gain the patient's trust, is kind of buying into maybe, some paranoid delusions or things like that. In his record, he'll talk about it and characterize it as a paranoid delusion. And so those are tricky because on one hand, I think my clients have the right to see what's in their file. On the other hand, if the doctor is saying this could theoretically damage their care and their future, the efficiency of the treatment, do you want to really release it? And so, if somebody, and it hasn't really ever happened in many, many years, but if somebody was to call me up and say, I want my file, I don't think I can refuse to give it to them. I can tell them that, I did see in the psychologist's notes that it was not be good for you to read this because these headsets are just kind of a little bit uncomfortable. The doctor felt like it would be detrimental to your treatment to read his thoughts about it. But again, at the end of the day, I work for my clients, so I got to do what they said. Bobby, watch your videos. Again, thank you, Bobby. I'm glad that you found the videos. And in fact, if you're so inclined, I will give you a link here. Let's see here. Here we go. Yeah, if you could leave me a review, if you found the videos useful, there's a place on there where you can say, he wasn't my attorney, but I saw his videos. I found them very helpful. That does help me as well. Reviews are very important to attorneys just because people read them. And I read reviews on Yelp and and Google and all that. I take them with a little bit of a grain of salt, but I think is a good starting point. So, when people are happy with my work or with what I'm doing here and they post a review, it really does help. So if you are inclined to do that, it would be greatly appreciated. And it actually does help me. Blah, 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 blah. Okay, Nickerson Mencio said that, okay. Okay, so I think that I remember seeing your case eval come through. I'll mark to take another look at that. I read that as being that you were in a continuing disability review, and I really don't take very many of those because people can't pay for them. I'll just be straight with you. Those who have continuing reviews, most people choose to have their benefits continue while they're being reviewed, which means there's no past due benefits, and nobody has the funds to pay an attorney. I think it's kind of dirty pull by Social Security because it doesn't allow people with CDRs to get attorneys. But if you've got a remanded case, we'll definitely take a look at that. So I will take a look at that in the morning or later this evening, and we'll take another look at that. I apologize. I just misread what you told me. In fact, I'm going to leave myself a note here to do that. Get my handy dandy notepad out here. And Nickerson Mencio. Okay, well, thanks for letting me know, and I will definitely check into that. Okay, so you did call them. They said they're going to, this is SA again. They're emailing the last 3 visits assessment. This is impractical. It is. Why won't they put it in the portal? It doesn't make any sense to me. Whether it's a deal breaker is a decision you've got to make, but that is a little bit unusual. Maureen, how does my Social Security disability convert over to regular retirement? Will be 66 and 10 on March 26th. Is that effective exactly 10 months after my birthday? It just goes to a different trust fund. I don't know the mechanics of it. I think that what they do is, it's all done in a computer, obviously. And once you hit retirement age or close to it, and they start the conversion, I don't think you have to do anything. I think the thing happens automatically. But I don't know the actual coding or what goes on in the office, but it's automatic. Okay, so St. Louis Grand this is the remand. He's been remanded twice already. And so I said usually the second remand they go to a different ALJ. So you had ALJ 1 who retired or left, went to ALJ 2, denies you, that gets remanded. Now it's going back to ALJ 2 because it's the first remand for that judge. That makes sense because they usually will send it back once, and the second time they won't. So hopefully ALJ 2 will read the tea leaves, read between the lines here. Tara, how are you doing? Good to see one of our clients who got approved. Good to see you here. Thank you for telling everybody to like and subscribe. I appreciate that very much. The young lady with psychological issues was with video. Okay, so somebody had asked about some psychological issues, and I think Mike is asking, would it make sense to do a video hearing for that? I think it's a judgment call. It depends on what I would do. And it's a very good point. I would probably do a video, Zoom call or something with the client. And if I felt like having her on video, whether it's because of a flat affect or because of odd behavior or whatever, it might make a difference in the way I would recommend, video or live. So yeah, but I would, that would be something that I would offer my opinion on. Look, I've had cases where, I of course I'm in Atlanta. I'm not in Atlanta now, but I'm based out of Atlanta. It's not really practical for me to fly to, Iowa or North Dakota for a hearing. So, if we can't do it by video or audio, I will find somebody in one of those locations just through my network that could help with the case. But if I feel like an in-person hearing is appropriate, then that's what I'm going to do. And I'll work out whatever I work out with the other attorney, or maybe just straight up referral. But, at the end of the day, your attorney's got to do what's best for you. And if that means a live hearing, then so be it. Look, I have one. I'll give you an example. I've got one that I had a client in Massachusetts that some reason got assigned to Charleston, South Carolina, and the lowest paying judge in Charleston and one of the lowest paying judges in the entire country. And of course and I told her, I said, what we might want to do here is request a live hearing, because the judge asked at the beginning of the hearing, are you okay with going forward with the telephone hearing? And I told her, I said, you could say no, because I'm telling you, this judge is not going to approve you. Now I want to go and get this out of the way. So we went ahead. Of course, we got denied. We're appealing it. If the appeal is successful and it comes back, I'm going to recommend to her that she request a live hearing, because if it goes back to the same judge, we're going to get the same result. Go to a live judge in Massachusetts, it'll be a different judge. Her chances are going to be better regardless. I mean, even if it goes, if it's a 30% judge is better than a 15% judge. So, you got to do what's right for your client. And hopefully we'll see if we get the appeal, take it one step at a time. Mike says, I won my disability case during COVID. The man I spoke on the phone was the judge. Yes, that is correct. The judge, it will be on the phone at the hearing. The judge, the vocational witness, a hearing reporter, you and your attorneys, typically the 5 people on there. And, many judges are, again, personal experience. I think a lot of judges like the audio hearings, the telephone hearings. They're comfortable in their house or their office. They're not being exposed to people, who are coughing and hacking all over them. I think that there's also an element that, at hearings, there is no security. So live hearings, so they don't have a bailiff like you see in judicial court. And I suspect that, judges might have some concern about their own safety. Maybe it's not even at a conscious level, but it's possibly there. I just find that judges just tend to be a little more relaxed, with telephone hearings. It's just, they just go, they're done. It keeps their calendar rolling. They control the calendar much better. It's easier to be just a little more casual. I don't know. That's my experience has been, it works really, really well. Why does the process take so long to get a denial approval? I think part of it is that there's always a delay between the time that this case starts being assigned to an adjudicator. So that could be 3 months or it could be a year, like I told you. So there is a backlog in terms of the number of people at the state agencies who do adjudication. They don't have enough of them. They're overworked. So, they send out these mass emails to request, not emails, mass letters to request medical records, and they hope they come back. Social Security pays, I think it's $15 or $20 for records. A lot of medical providers are used to getting paid hundreds of dollars for medical records. And, Social Security is last on their priority list. So I think a lot of times records don't come in and they have to diary to request the second time. They're always going to request them twice. And if it didn't come in the second time, they will send out records, they diary for 6 weeks. And if it comes in, great. If it doesn't, they send out another. So now we're another 6 weeks. So now, we're at 3 months and maybe there's a couple months. So you can already see you're at 5 months before really anything happens. Then they have to send it to a medical specialist who's also got a lot of cases stacked up. They may take a month or two to review it. Then it comes back. The adjudicator has to see if there's anything else that's come in. It's all diaried. But if you are juggling 150 files, at any one time, maybe you look at a particular file once every 2 weeks. It just time drags on. They just don't have enough people. And, this is where I think AI will probably start to become more of a factor where, you may start to see adjudicators using AI to evaluate medical records. And, maybe that'll speed things up. Will it make it more accurate? I don't know, but it'll speed things up, I'm thinking. Christina. Thank you, Christina. Christina is one of my I think you missed maybe 1 or 2 of these. I really appreciate that. You are one of my, I guess the part of the fan club, which I appreciate. Thank you very much, Christina. Mary. Oh, absolutely, Mary. That's why I do this. Cindy says, thank you. Absolutely. Okay, they're our best lawyer. Can I go on the C, 6 months in Holland? If you're on disability benefits and you take a cruise, is what you're saying, or you're taking you want to go to Holland to visit family or friends or travel or whatever. I think that anything you do outside of your home, you need to be able to explain if you're asked what you did and why you did it. I've had people, I remember I had a case maybe a couple of years ago where I had a client who had gone to France because her daughter, because of a birthday or something, had promised her, when you hit a certain age, I'm going to take you to France. And, the lady, testified that she, had a really, really difficult time, couldn't do a lot of the touristy things, was mostly in a vehicle. But, if you're a judge, you're looking at saying, well, this person, got on an airplane, flew 12 hours, dealt with all the nonsense that you have at airports, had to get in and out of cabs or Ubers, had to sleep in a strange bed. Is it a little inconsistent with being disabled? Yeah, probably so. Does it mean you're not disabled? No. But I just think, the judge is going to want to know. The judge will sometimes say, have you been any place more than 30 minutes away from your home in the last 2 years? They want to know, have you ridden in a car? Have you been in an airplane? Because if you're saying I can only sit for 15 or 20 minutes, but you rode in a car for 6 hours, not really consistent. Now, my case the other day, I had a client who testified that he went to his son's graduation, which was, in a city about 6 hours away from where he lives. He says it took him 12 hours to get there because every 30 minutes they had to stop for 10 or 15 minutes so he could stretch out. That was how he explained it. The judge was okay with that. Had another case where my client, and we were still trying to decide what to do with this one. She testified that she owned a motorcycle. And I'd asked her about it. I said, why do you still own it? She goes, I'm not driving it. Why do you still own it? She goes, well, I really worked hard to get this motorcycle. It's got an emotional attachment. I just can't get rid of it. Well, the judge, kind of implied that he felt she was riding her motorcycle. She swears she wasn't, but, I think it was in the medical record. She testified she owned a motorcycle. That ended up hurting her. So, it's just really going to depend on the situation as far as, if you travel. But I think you need to be able to explain why you traveled, what was the reason for it. Sometimes it's because it's cheaper to get medical care there. Maybe you're from there, you have sick relatives, or you want to visit family and friends. But you want to be able to explain what you did and why this is not inconsistent with your claim for disability. All right. SA says, I have medical records from 2020 and 22 that add to the current ones, but the paralegal said don't send them because of their age, and the SSA would ask if they wanted them. Yeah, what he's getting at is, or she, I'm not sure, SA, if you're he or she, I don't know, that sometimes you offer to send Social Security records and they say don't send them, they're too old. You know what? I send them anyway. I mean, if I think they're relevant, I'm an advocate for my client. I'm going to send them in anyway. If the judge doesn't want to consider them, judge doesn't have to consider them. But I think if they're relevant, to your situation, then absolutely. Now, they're going to look, typically what Social Security is going to look at is about a year to 18 months prior to your onset date, because they feel like if you were working, let's say in 2020, SA was working full time and going to the doctor, obviously the medical records are not going to say that SA can't work. What it could say, though, is there is a ongoing problem that's getting worse and worse. And that history, I think, it can be very relevant. So, in a brief, I might refer to it, talk about, the claimant has a long history of treatment. Let's just say it's back problems, long history of treatment, going back to 2020, there's no MRI evidence. We don't know what's going on, but, my client was complaining of back pain and continue to complain. And then finally in 2024, we have an MRI that shows a herniated disc or something. So, having that, they call it a longitudinal record, I think can be very relevant. Now, again, it's a judgment call. If it's something that, let's say medical records that are really not particularly relevant. Let's say that let's keep it in the orthopedic realm. Let's say that your claim for disability is based on the after effects of a severe car accident. You have that car accident in 2024. You're going to the doctor for kind of a mild backache in 2020 or 22. Is that really relevant? Probably not. That would be something that, you might hold off on. So it's just going to depend on the facts and circumstances. But, everything else being equal, if it's going to give the Social Security or a judge kind of an overall big picture, I say submit it. Yes, Christina, thank you very much. Thank you for the suggestion. Great, Denise, thank you. That's a very good point. I mean, and again, I'm glad you had an attorney. I think that this process can be pretty daunting. It shouldn't be, honestly, it really shouldn't be, but it's kind of evolved into this very complicated, all these abbreviations, and there's processes and procedures and arguments and acronyms, and it's very hard to sort of muddle through. And you got typically one bite at the apple. And, I realize 25% of past due benefits is capped, but it's 25% is a lot of money, but 100% of nothing is nothing. And I think that, what Denise is saying, I agree with most of the time. It does make sense, especially if you don't get approved at the initial level, to bring somebody in to assist, because otherwise you're just really having to learn about it, a lot of stuff, and hope that you get it right. Whereas, I've done this for 30 years, so I kind of know what they're looking for. Doesn't an adjudicator make his decision with what he gets, will not ask for things he hasn't received? Well, again, the adjudicator is going to request medical records, whatever comes in as part of the file. Then they've sent out a second request, diary that for 6 weeks, and see what comes in. At that point, they've done their due diligence to get records. If they have time, they may follow up a third time, they make a phone call. What they don't do, well, I would say don't ever. Rarely do I get a phone call from an adjudicator saying, look, we need these records. Can you help me get them? That happens very, very rarely. I don't know why. I mean, that's kind of my job, but they don't usually ask me. But yeah, if it doesn't come in and they only have an incomplete file, they make a decision. I can't tell you how many times I've reviewed denial notices where it'll say, we use the following records to evaluate your case. The additional records we requested, but did not come in, were not made available to us. And they may list 3 or 4 doctors, including the orthopedic surgeon who did your back surgery in the hospital where the surgery was done. And as frustrating as it can be, because, they couldn't get them and they really didn't ask for a lot of help. And it's, that's sort of something that, we can certainly help with. And I wish they would ask, but, I think they're just they just do their own thing. And I guess they're just busy. I don't know. Canova Henry. I was told when I moved from Florida to Pennsylvania, get more. No, your disability amount, your disability amount. Now, whether there's a supplement in Pennsylvania, I don't know. That would be unique to Pennsylvania, but the SSDI amount will not change. That is based on your earnings record. James Rex says, thank you. You're welcome, James Rec. Thank you for tuning in. RD is in Orange County, near we're in California. Okay. Orange County, in the LA area. Generally speaking, very nice. I hope you didn't get hit by any of those fires that they had last year. I know Christina is in not too far from where the fires were, and she said it was getting kind of close. So I hope you didn't have any of that. Any idea with next year's COLA? I do not. I thought I saw something coming out, but it hasn't been, to my knowledge, has not been released yet. I don't know. Let's take a quick look, and let's see if there's anything on the 2026 COLA. 2026 COLA. Social Security. It's projected to be 2.7%, according to Google. So 2.7, on average will mean about $54 more in your check. That's what Google's telling me. Is Google always right? Nope, but that's what it's telling me. Sam, I am. I just received a fully favorable. That's great. Thanks for the videos. Great. I got a letter from LTD. And of course, LTD is going to ask you to repay them a lump sum. You probably have agreed to provide your LTD carrier with your Social Security file, um, I would say this: if you had an attorney, run that by your attorney. I'm not going to tell you on a live stream you should do something, because without having all the facts in front of me, like I said, my experience has been that most of the time the LTD carrier has already secured your agreement to do this. So they're just asking for the formal authorization. If you had a reason not to, and your attorney can set that out, then maybe not, but I would talk to your attorney about that. That's really more in the realm of personal, specific advice to your situation. 59, phone bone. I'm on SSDI. You have to tell us Social Security before you start a 12 work period. Can you start about 6 months from full retirement? They tell you that you need to tell them about it. They of course get the tax records. You're close to full retirement. It's, I tell my clients when they ask me this question, it's a judgment call. If you want to tell them, tell them. At the end of the day, if you have to keep track of your own trial work period, and whether if you tell them and you exceed it, it's not going to, that doesn't help you any. I've had people also tell me that they've called Social Security to tell them I'm starting a trial work period. The person who answered the phone says, that's great. We don't have any place to put that information. So, if you wish to, follow the rules exactly, send them a fax, send them a letter saying I'm about to start a trial work period. On the other hand, you're getting close to full retirement age. Is it worth the complication? It's just kind of a judgment call. Maybe what I would do is if you can get through to the local office, call the local office and say, I'm thinking about starting a trial work period. How do I notify you? And see what they say. But I tend to, believe that the less, things you make complicated for Social Security, the better. House of Joni, bad infection in my spine. Ooh, I've seen a pain doctor for 6 years. Okay, if I refuse shots, a high risk? Yes, absolutely. There is a Social Security ruling that basically says that if you choose not to pursue a particular type of any kind of invasive treatment or potentially dangerous treatment, that will not be held against you. So that is not a problem at all. Just need to make sure it's in the record and that you've documented it. Just maybe write your doctor a letter or an email saying, I know that I have had certain shots that have been suggested for pain, and I've decided not to go there because I had an infection and I'm really concerned about another infection. And that's why I'm refusing them, not because I don't want to get better. Just cover your tracks. That way it's in the file. So if somebody questions it later on, you can explain you told them in a, in a proactive way. Mary says, love your video. Thank you, Mary. I appreciate that very much. Yeah, have a good time with them. I've been doing more shorts lately. I'm also trying to build up my Instagram channel with a little bit different, some usually shorter videos. Let me put this on here. So yes, if you happen to be on Instagram, go ahead and subscribe to it. That's let me just put that there. Okay. Yeah, just check it out. Again, a lot of them are the same videos I put in the YouTube Shorts, but I've got a couple of different ones, and just trying to build up Instagram. I've relied on YouTube as a big source of clients for me, which is great. But I want to test out some other places, and Instagram is nice. In fact, at one point was trying to syndicate this live stream to Instagram. The problem is, at that time, and it's probably still the case, they only let you do an hour. So what was happening is, and I didn't have enough people watching it anyway on the Instagram. But it's another channel, and people are using it, and I'm going to do it as well. So if you get a chance, please, if you're on Instagram, please subscribe to it. Okay, let's see what we got here. And we've got Mike. Mike is just great to discuss. Thank you, Mike. I appreciate that. Yeah, I'm a big believer in sharing what I know. I mean, this is not brain surgery. It is something they don't explain very well. And if I can explain it better, then that's what I'm doing it for. Good karma. Hey, Sharon. Okay. We are, thank you for the review very much. And I know Jen, we've been trying to get your benefits paid. I honestly, I've been sort of out of the loop a little bit, so I hope that they did. But I know that was something that we talk about in our meetings. We, have our team meetings at least once or sometimes twice a week. And that was one of the things I'm like, we got to get Sharon her money. So I know that I know Stephanie was working on that in my office. So hopefully that actually happened. Tarzan Walker, great name. I've never heard of another person named Tarzan, so that's awesome. Great name. Reconsideration for 6 months. Just turned in my SMI benefits letter for any advice on where I'm at. What is SM? I don't know what SMI benefits is. Let me see if SMI. Let's see what that stands for. I don't know. It doesn't, unclear. Arizona serious mental illness, maybe. I don't know. I don't know, Tarzan. If you could explain, that would be helpful. I don't know. Nickerson, what do they take too much money? My check for Medicare because they don't take Medicare on their time frame. What I tell people with regard to Medicare is there are a couple of people that know a lot more about Medicare than me, and I would be happy to give you their name. Just to call. If you want to email me, Nickerson, ssdanswers123@gmail, and I'll send you the names of the people I refer to for Medicare, and they can answer your question. I just don't like to speculate because I don't deal with Medicare issues per se. Canova says, I'll be 55 on September 27th. I wonder if I can get an answer from SSI in my case. At 55, things do change. Let me go back to where you were before here, if I can find it. Well, let's just say this. At 55, it becomes easier to win. And so I've seen many situations where Social Security will approve somebody as of their 55th birthday. So that may happen here. So just be aware, and you've got to make a decision. Do you appeal, try to get extra benefits? And again, my sort of rule of thumb is if you're going after $5,000, $6,000, $7,000 of benefits, is it really worth risking your case on? Because if you appeal and you goes back to another hearing, a whole new hearing, or if you've been approved administratively, you get in front of Judge 5% and you're in big trouble. So I've seen a lot of cases where I'm getting an approval, but my client's approved as of his 55th birthday or her 55th birthday. And that cuts out a lot of past due benefits, and that's just a judgment call you got to make, but it will make it easier to win. House of Joni. Very good question. I'll be 55 in May. My court date will probably be in a few months, so too soon to ask for 55 grid. There is a rule that says basically that if you're within a few months of that milestone birthday, that they can use that grid rule for you. In fact, the case I had, let me see if I can pull this up real quick. I can read you the language, but the case I had with the judge who really very rarely approves anybody, he referenced this in his approval. Let me just pull this up. I'm going to read it to you, what he said here. Like I said, I fell off my chair when he approved this case on the record. My client was thrilled, but okay. As he put it, she was 54 and however many months. He says a borderline age situation exists, but if the claimant is within a few days to a few months of attaining the next higher age category, and applying the chronological age would result in the denial of title to benefits. Use for the next higher age category is supported by the significant adverse effect of all factors on the claimant's ability to adjust to other work. At the alleged onset date, she was 54 years and 10 months old. Pursuant to the POMS regulation, I find the claimants within 2 months of the next higher age category at the alleged onset date. The higher age category result in a decision to disabled, that the time period under review at the same residual functional capacity as the next higher category and a finding of no past relevant work remain the same. Accordingly, under the borderline age rules, I find the claimant should be considered at the next higher category of age. So that's literally reading from a decision from a judge who is very reluctant to approve anybody. So the answer, my point is, if you're 54 years and 10 months or 9 months at the time of your time of your hearing, then the borderline age situation applies, and you could ask them to use the grid rule for 55. Thank you, Christina. Appreciate it. That I get garlic ice cream. 59 Phone Bone knows that Gilroy is the garlic capital of the world, I think. And I like garlic, in spaghetti. I like it in, a lot of things, and scrambled eggs, but not in ice cream. I like ice cream. And my wife will tell you, because we've been down here and I'm on a vacation. So she seems to think that pizza and ice cream are not appropriate meals for every other meal. And she's obviously wrong about that. So I really do like ice cream, but not garlic ice cream. I will tell you that. It is actually, and just speaking of strange flavors, in Atlanta where I live, that's where Coca-Cola is based. And they have something called the World of Coca-Cola, which is like an attraction downtown. Not a lot to do in Atlanta, but the World of Coke is there. And they have all these drinks. If you go there, you pay them $20, whatever, and you can sample drinks from all over the world, Japan and China and all the different countries. And some of the flavors are just weird, that we're not our taste here in America. I don't think there's anything garlic, but I know that there's a lot of, like seaweed. There was all kind of crazy. But if you ever get a chance to check out some of the unusual flavors that Coca-Cola makes over the world, it is interesting to see. But I don't think there's any garlic. But no garlic ice cream. Although I don't doubt they have it, but I would not be interested in trying that. Dimple is 59. I had a total left knee replacement on July 22nd. Doctor did not specify return to work. Disability department elected a return to work date of next Monday. When I mentioned to my doctor, part 1. Dimple, you kill me. I'm going to find the rest of it here. Here we go. The return to work doc provided extended leave 4 weeks and no restrictions. My job is 100% sedentary. Need to move to present edema. I feel like I've hurt myself from a future case. I think you're basically being asked to work, maybe a little bit beyond your capacity. Returning to work, realize disability is defined as not being able to work. So, a knee replacement does not make you disabled. I mean, if the knee replacement did not go well, or if you have restrictions, different story. Now the question jumps in my mind. At 59, you would grid out at light. So being able to do sedentary work does not stop you from being deemed disabled, because you could do light work and be disabled. But the question is, are you going to go back to work? If you're working, earning more than $1,620 a month, then there's no case. But if you decide to discontinue work and you've got a return to work that limits you to sedentary, then you still got a case. Now, if you have a return to work that gives you no limitations, that is a problem, because Social Security is going to see no limitations. Well, you could stand and walk for 6 hours a day. So you need to get some medical support for the idea that you can't stand and walk for 6 hours a day. That puts you at the light grid rule, and assuming you have transferable skills, you win. But you got to get, you can't have it if you have a full duty, no restrictions, return to work following knee replacement. That's not going to bode well. So, my thought would be, I would tell you to try to go back to work, see what happens. If you can't work, you can't work. And you have to make a decision about whether to pursue disability. Because again, you may win, but it may be 2 years from now. So is it better to be working and earning money every month, or to sit at home for 2 years waiting for Social Security to adjudicate your case? I would tell you better to work if you can work. That's really I think that's the gist of this, is that you've got to have medical support to limit you to to light work or less. And if you do that, you have a grid rule argument probably. Amazing Grace, thank you for doing those lives. My pleasure. Thank you for tuning in. I wouldn't do them if people weren't watching, and I got 116 people watching right now. Trying to get more, so tell people. But yeah, that's why I do them. Kenny Loomis, do you know what's happening with the Windfall Elimination Act for people who work in education? A fund with or away it, but I've never heard they. I don't know much about the windfall elimination. I think that what it does is it makes you eligible for more benefits, so it's not a bad thing. They were counting one type of benefit against the other, reducing what you got. I just don't know enough about it to comment. I'm sorry, I just don't know. I'm going to have next week. I'm going to have a lawyer named Andrew Sindler on. He's scheduled to be on. Hopefully, he will be able to come, and he may know. He does a lot of speaking about some of these little more esoteric topics. So let's hold that thought and see if Andrew has any thoughts about that, because he may know more about it than me. I'm sure he has to, because I don't know anything about it. RB is 52 years old, applying for associated musculoskeletal. Depression was listed in denial, received meds through primary. Don't see a psych doctor. Can this hurt ALJ hearing? I think it's going to hurt. I don't think it's going to give you a lot to work with. It sounds like this is mostly musculoskeletal. The depression, you can certainly testify about how it affects you. You're on meds, which may have side effects. I think, the question, I analyze this as follows. Social Security uses something called a 5-step sequential evaluation process to evaluate claims. Step 1 is, are you working? Okay. Obviously, you don't want to be working when you're applying for disability or working at SGA level. Step 2 is, do you have a severe impairment? And if let's say you list a problem on your application, but you're getting little to no treatment for it, the judge could decide it's not severe. It may be the judge in your case decides that depression is not severe because you're only getting meds from your GP. On the other hand, you're getting meds. And any type of psychotropic medication, in my opinion, is inherently serious. So I think you can probably get past step 2, and then step 3 of the evaluation is, do you meet a listing, which I suspect you probably don't. Step 4, can you return to past work? Step 5, can you do any other kind of work? So this is probably going to boil down to whether your musculoskeletal issues are severe enough to disable you. The depression might add a bit to it in the sense of making it difficult to maintain attention and concentration, maybe not to be, in terms of a hypothetical, that you would be limited to 1 or 2 step simple tasks, that you wouldn't have to be interacting with coworkers or supervisors, not dealing with highly stressful situations. It would eliminate certain categories of jobs, but it's not going to be enough on its own. If all you had was, I'm depressed and I'm getting meds from my family doctor, that's not going to be enough. But it might be enough to help push you over the finish line, if that makes any sense. I don't think it's going to make it be a huge factor, but it's another, in my opinion, a severe impairment that should be considered, that might have eliminate certain jobs and make the job base reduced. Okay, so DJ Mike, and I guess because you're a DJ, you probably are. I'm not being facetious. You probably are very well spoken, and you probably have a very the way you talk, you probably can express yourself very clearly. So so when you do a hearing, if you do it on your own and you go to a hearing, the judge will call, or the judge's office will call, and you'll be talking directly to the judge. There's some judges I know that make the calls themselves. Like I'll get my hearings at 10:30 in the morning. I'll get a phone call at 10:30. Mr. Ginsberg, yeah, this is Judge so-and-so. Okay. I had one the other day where the judge was like, yeah, the hearing reporter system is broken, so I'm making all the calls myself. Like, that's fine. But most of the judges, these are administrative law judges. They are federal employees. They are not judges like you would see in state court or federal court. They have to be approved by Congress. They're not elected like they are in many states. It's an appointed position. They're still judges. You treat them with respect. But I don't think there's a lot of these administrative law judges. They're not they don't maybe see themselves the same way as a federal court judge might. I think that they are, typically a little more modest than that, if I had to say. So most of the judges are pretty reasonable. Some of them are just actually quite friendly. There's a couple of judges I know, they're just, extremely, they go out of their way to make my clients feel very comfortable. They're very friendly and complimentary to me, which I appreciate. And, there are a couple of judges that, if I have a case I think that should be approved on the record, I could call up and say, Judge, I got this case. Can we take a look at this for possible on the record? And they'd be fine with it. Other judges I wouldn't do that with, but you just have to kind of feel your way through. But yeah, if you get a good judge, and I always look at, there's a couple of websites you can go to find out. In fact, I'll put one in here so you can sort of see it. I'll put this in the comments here. This is a website that I go to a lot. And what this does is you can enter the judge's name and it shows the approval rate. And I'm not sure how up to date the stats are here, but it gives me a pretty good idea what's going on. Okay. Tip Witherspoon. I'm still going to a different specialist. I report to my attorney. Does SS get the results immediately? Not until they request it or your attorney uploads it. So it's not an automatic process. Something's got to happen. Must I keep my specialist that gave me my diagnosis? Got SSDI. Doesn't help me anymore, but I still see my primary doc every 6 months. I think as long as you're seeing your primary doc, that's a good thing. I don't know that I would completely eliminate seeing a specialist once a year. Just in the event that there is a CDR, you've got more than your family doctor. I mean, that's the cautious part of me. I don't know that I would necessarily, discontinue or just fire the doctor. Just say, I'm not really getting any benefit from this. Can I see you as needed, and see what he says about that. Okay. Do all attorneys have access to EMRs on their client? Now you give me all these abbreviations. What is an EMR? Electronic medical record. Okay. Well, if you have an account with the ERE system, Social Security a number of years ago went into this system. It's called Electronics Records Express, or ERE. And if you do this work, you sort of have to be part of this. I mean, they want everything uploaded now. It's all paperless. But I remember when I first got approved for it or got registered for it, pardon me, I had to go to a meeting, a training session, had to be interviewed, had to, I think, submit like an application to be approved for it. And, I went to this office in the middle of it was in some office building, in the bowels of some office building, went through a training and got approved for it. I think it's probably easier now. But basically what that means is that I can access my clients' files electronically. And in fact, what's gone beyond that is there are a couple of companies. One is called Assure, one is called Chronicle, and I use both of them, where it will download the file as one searchable PDF. Very, very useful. So my answer would be, if any attorney who doesn't have ERE access is trying to, has a hand tied behind his back. I mean, you have to have it, I think. I think the answer would be anybody who does this for, more than just dabbles in it, which would be not a smart thing to do, I think would be wise to have it and should have it. Shane is 54, will be 54 next month, worked all my life, lost my right eye to retina attachment, must get surgery on the left, able to drive as a serious risk. What's my chances of filing? If your primary issue is visual, I find that you almost have to meet a listing. And if you look at the listings for visual, they give very specific test results you've got to meet. So if you go to meetalisting.com, my website, and click on the link that says take me to the listings, and look at the listing for special senses and speech, you will see, I think there's 3 listings for visual. and you just see whether you meet one of those. That's good, unless you have nothing else going on medically. I was 55 when I applied, present with spinal cord stem implanted. Yeah, you're 55, puts you in grid rule territory. Spinal cord stimulator suggests that you really have not benefited much from surgery or other maybe invasive procedures. So not surprising that you won. I'm glad you did. But I'm curious, do you find the spinal cord stem works? Do you get any benefit out of it? I've had people tell me both ways. Amazing Grace says, I followed you for so glad. Thank you, Amazing. I appreciate that. That is very nice. Christina. Thank you, Christina. I appreciate that very much. Christina, I think Christina is looking to get on the payroll as my fan club director, which she'd be number one on the list if I had a fan club. But thank you very much, Christina. Very sweet of you. Would volunteering a day a week? No, I think that, again, volunteer work can be SGA, but one day a week is not going to do it. But look, anytime you do anything other than sit at home, I had to put it this way, if you work a little bit, if you volunteer a little bit, it increases the risk marginally. You get a CDR, you're volunteering one day a week. Might they conclude, well, you could volunteer one day, why can't you volunteer 4 days? And one day a week is probably not going to really move the meter very much. 3 days, 4 days, maybe. But I don't think that's really a problem. I would never tell a client of mine not to volunteer because I think it's, it's a good way to keep your mind active. So I think it's okay. Essay. I've sent no records to SSA. I saw my attorney's website. Want to abide by the pre-legal instructions, these are ahead of the psychological problem. Yeah, I think that's the right way to do it. You have an attorney, let the attorney do his or her thing. Muley. So it was approved for musculoskeletal and secondarily PTSD. I'd be curious, Muley, did you find that the decision or that the focus of the hearing was more on the musculoskeletal? What part did the PTSD play in this? If you remember what your decision said. Okay, so Dimple's one just had the knee replacement, advanced RA with osteoarthritic deformity of my right dominant hand, advanced arthritis both elbows, and orthotism replacement, feeling defeated before I get started. Well, again, I think at 59 with all these problems, I think you got a pretty good argument. The knee replacement, you got a full duty release, not good. But on the other hand, a judge could look at it and say, I'm not going to expect somebody with a knee replacement, and again, if it went well, look, knee replacements, people go back to playing sports after knee replacements. So it's not inherently, going to disable you, but certainly for a period of time. But if you have any evidence to suggest that it might be good for you not to be in your feet for 6 hours a day to get you to that light limitation, or if there's any, look online, is there any suggestion that someone going through a knee replacement needs to limit how much they lift or limit their, the way they, squat or bend or whatever? And those can be introduced into evidence. Then you got all this other stuff. You've got the RA, you've got problems with your right dominant hand, arthritis, elbows. Can you really pick up 20 pounds? I can't see you picking up 20 pounds with a deformity of your right hand and advanced arthritis in your elbows. So you may very well meet the grid at light if you have no transferable skills. Okay, RD is about 75 miles away. So, okay, so it's still kind of scary because those things move very quickly. I have a first cousin who lives in Culver City, and I know she was, they had everything packed up, and they were concerned, but fortunately didn't get them. Okay, Mary says, I refuse to use epidurals. If I refuse epidurals in cervical and lumbar spine, will that hurt my chances? No, if you have a reason for it. If you feel like that there's danger because of infection, like somebody talked about before, or you feel like that, just the risk of it not working, or you had a bad reaction to the medicine, as long as you give a reason, I think you're in pretty good shape. But it won't. There's a Social Security ruling in particular that says they will not hold that against you. Old School, Chicano 74. I'm in Sacramento. Can you represent? Yes, all the hearings are done by phone or video. So if you send me let me put that link up there. If you send me a case eval, I'll take a look at it and just make sure you note in there that you saw that, or who you are from the live stream. All right, so here's the link for for that. Tcash. You're welcome, Tcash. If I'm on SSD, I'm more than 40 quarters. Can I go to retirement, Social Security, maybe work part-time? I don't know that you can. I mean, I don't think it would think. Well, you can still work part-time on SSDI. Let's start with that. Secondly, if you go to early retirement, you're going to take a pay cut. So I don't know that I would think that makes a lot of sense. I mean, if you've had an SSDI attorney, ask your attorney. I'm thinking, though, you can work part-time under disability, again, stay under that 1,620, and you're fine. Now, if you're going to earn more than that, if I'm not mistaken, with SSDI or SSA early retirement, there's a limit on what you can earn anyway. So until you hit full retirement, you know, where there's no limit on earnings, I think it probably makes more sense to stay on disability. But I would ask your attorney about that. But I just doesn't make sense to me to take early retirement at 62 if you're on disability. House of Joni. Should I choose phone? Yeah. I think phone's fine. Honestly, I can't think of a single time when I regretted choosing phone. So I think you're fine. And thank you for the review. Appreciate that. Alan Hurd. Currently working my case from March of 24, 61. Is there a chance when I hear something soon before I sign up for SSI? Okay, Alan, when you say SSI, you mean early retirement? I think you mean early retirement. Let's see where we are here. I don't like to talk about individuals' cases because it's all confidential. Okay. You know what? Rather than me discuss let's just see if I can see anything here. Nothing's showing me anything. Okay. Alan, let me do this. Let me pull the file. I don't like talking about my clients' cases specifically, just because it's confidential. You obviously have indicated that I'm your attorney, so that not revealing anything there. Let me reply to you directly. How about that? Okay. Let's see here. Style with I made a note to myself here too. Now you got me curious though. I'm going to check something. Okay. How much harder is to win with a former executive assistant job? I am almost 55 with a pain doctor for 5 years. Don't know my pain doctor will help me writing much. I have worry. Well, again, at 55, I've won cases without a lot of support from. I've won cases without a lot of support from medical doctors in terms of functional capacity forms. You're on pain meds. It really is going to depend on what the underlying evidence shows in terms of your diagnosis and what's going on. So my point is that if the doctor will not help, that is not inherently a problem. I don't think that's going to mean you aren't going to be able to win. So if the pain doc won't fill out a form, the records may be enough. It's just going to depend on what they say, what the MRIs say, things like that. I think the other thing you got to be concerned about is transferability of skills. You're an executive assistant. You no doubt have skills that could be transferred. So you have to get rid of those by arguing pain. But I think you need to have, probably some MRI evidence that shows some significant issues that would get you through disability. And then the pain part would eliminate the transferability of skills. So what I'm getting at is the objective evidence like the MRI is probably going to be more important than the pain doctor's lack of cooperation. Thank you very much, Stahl, without trial. Thank you for your kind words. I'm going to keep doing them because that's what I do. I've been also scheduled for 3 different exams. The last of the 3 is the 4th of October. That's good in the sense that your case is moving along. Now, will it mean you're going to get an approval before you hit 62? Can't say that, but I'm glad the case is moving along. That's always a good thing. I'm just looking here. Yeah, I can see why you're having 3. Okay. I'll reach out to you. I don't want to go into detail here for obvious reasons. Okay. Christy, hadn't seen you in a while. Christy, how can we only get 4 work credits and you're not 5? Why is the ability to get insured under these credits expire after 5 years? These are really smart questions, Christy. I appreciate them. The answer to the first part is you only get 4 work credits is because that's what Congress put in the law, that you can get 4 quarters of credits in a year, and that's it, no more than 4. One thing that did change a number of years ago used to be that you had to have the credits in, the earnings in quarter 1, quarter 2, quarter 3, or quarter 4. So if you had all your earnings in quarter 1, you wouldn't get 4 credits, you get 1 credit. Now they say you get all 4 credits. If you earn the requisite amount, you can earn it in the first week of January and get all 4 credits. I think it's like, I don't know, $1,900, something like that to get a credit. So I think you're like at $7,700 to get all 4 credits for the year. So if you earn, let's just pick $8,000, you earn $8,000 in January of 2026, you'll get all 4 credits. But it's just because Congress made it that way. There's no logical reason. And as far as the insured status, why they only look at the last 10 years, no answer to that either, other than that's just, it's a way for them to, I guess, to limit disability to people who have a recent work history, save money. I don't know that I've not seen any explanation for that any place. That's a very good question. I don't know why they don't look at your lifetime. They just don't. A lot of this, I think, has to do with saving money, quite frankly. I think that, they want to, to limit the number of people on disability. And if they can limit it to people with recent work histories, they'll do that. Okay. Thank you again, Christina. Candy Loomis. I'm in California. It's going to be an issue here. It used to be, I'm not sure, Candy, what you're talking about, the state disability and the offset, getting that taken care of. I would understand. Yeah, it can be. What constitutes, Shane says, disability in regards to eyesight? Okay, let's just take a look at the META listing, and I will show you. Let me share my screen here. Okay, so what you need to do, Shane, is go to metalisting.com. This is my website here. Then you click on here to go to the listings themselves. And if you see listing 2, special senses and speech, oops, I got to change. Okay. And you will see here, there are 2.02, 2.03, 2.04. These are the 3 listings that you can meet in order to win. And so they define, if you look up here, they define, what a visual disorder is and how you define. There's a lot of explanation behind what all the testing is. So I'm not going to go through all this, but if you look at it or print this out, take it to your doctor, you will see they have different, visual acuity, and they talk about the different types of testing and all that type of stuff. And how do you evaluate it? And you see it's very, very long. And then you actually get to the listing itself, is remaining vision in the eye is best. The better eye is left to 2200 or less. Then this other one is the widest numbers. Talk about an angle, point of view. Again, it gets very technical, but you really need to look at the listing 2.02, 03, and 04. Take it to your doctor and ask your doctor if you meet one of these listings. I think you mean like, Christina, not light. You want to press the like button. Absolutely. Um, um, yeah, style will try. I mean, I think that, you don't ever make a mistake telling your doctor if something is working or is better. I mean, you want to be straight up. And if things get better, they get better. I mean, at the end of the day, you're better off healthy than on disability, I think. But, I think you just want to be straight up with the doctor. I think that comes through in the record. And I know the judges like the fact that people are, if they get better, they're reporting they get better. Okay, what about individual legal blindness and other disabilities? And that's very nice to help your friend with this. I mean, I think that if you have a visual acuity, realize the way I look at disability is when I'm looking at a case or preparing for a hearing, I'm looking at everything to the idea of how can I eliminate categories of jobs? Because let's say if there are, pick a number, 10,000 jobs that exist in the economy. What percentage of those jobs require fine visual acuity? Let's say 4,000 of those jobs require fine visual acuity. And then of those 4,000 jobs, so we eliminate those. That means we have 6,000 jobs left. Of those 6,000 jobs, how many of those can you do if you can't lift more than 10 pounds? Well, now maybe you eliminate another 3,500. And then you just eliminate jobs by category. So the more things you've got going on that have vocational impact, the more jobs you can eliminate. And at the end of the day, we get to a hearing and the judge has a vocational witness and the hypothetical question says, I want you to assume a person of this age with the following limitations. And the more limitations that are put in that hypothetical, the harder it's going to be for the vocational witness to find a job that you could do. That is our goal here is to basically convince a judge that there's not one single job in the United States economy that somebody could do given all the limitations. And they use, to identify the jobs, a book called the Dictionary of Occupational Titles, which you can look at. Occupationalinfo.org is the website for it. And it lists every job. Now it's outdated. They use other sources now, but they still use the DOT codes. So again, the goal is to basically say there's no job I could do. And how do you do that? You basically, most of the time it's going to boil down to you would not be reliable enough. You'd have to take too many unscheduled breaks. You'd have to miss too many days from work because of pain and other symptoms. And that's usually what does it. And, so every once in a while you have a case where just there's so many impairments that it's not about being off task. It's about just so many things you can't do. But I'd say 95% of the cases I try, it boils down to being just unreliable because you just are going to miss too much time. And that's what you got to do. All right, Alan, I see you're 100% disabled vet. I do see that. And that's obviously a very important factor in the sense that it gets you to the front of the line. So that will speed things up a little bit. Thank you. Yes, I appreciate it. You live in Nepa, Northeast Pennsylvania. You're not just covering your state. Yeah, I mean, because I will tell you, when everything went virtual allows me to cover cases all over the country. So it helped me really grow my practice. But yeah, I enjoy the work and I find that it's gratifying. And if I can help people win disability, nobody gets rich doing Social Security disability from the attorney's side, but make a decent living. And, it's really fulfilling when people are nice enough to leave me nice reviews or send me emails. And I really appreciate that. So, but thank you for the kind words. Would being able to bend enough to barely above your knees or during a CPL major, we're being denied about squatting, what is non-qualifying for back? I mean, I think that, I don't look at non-qualifying or qualifying. I just think that if you cannot bend over to touch your knees, that's going to tell me that any job that would require you to bend over to your foot level is going to be eliminated. If the doctor believes that and documents that. And same with squatting. If you can't squat, that's going to eliminate jobs that require squatting. So you almost look at every impairment and see how does this affect functionality at a job. Yeah, EMR, electronic medical record. That's what I thought it was. Okay. Mike said that the judge told me to save his voicemail and phone number. I do have one question. I was 56 when disability was approved. My payments increased when I hit full. No, it'll be the same, about the same amount. I think that the full retirement and disability are about the same amount. If you can get a My Social Security statement, it'll tell you exactly, but it should be about the same. It won't go up though. How long does it take for redetermination or reconsideration? Can it take 2 to 3 years? Thanks for the kind words. Normally recon is going to be about 9-10 months. It shouldn't be any longer than that. If it go, I've seen it, at worst I've seen lately is about 1 year and 3 months or so, but no more than that. So if it's going on longer than that, you need to talk to your congressperson to find out what's going on for you. You're currently 60. Okay. So interesting. The judge told you to save his phone number. Huh? That's interesting. I've not heard judges do that, but that's cool. That's fine. Yeah, I told my nurse I can't afford a new MRI. Yeah, it does help to have a more recent MRI. And a lot of these MRI places will do them for $350, $400. So it's not a ton of money. But yeah, it's hard to win when you go in with MRI that's 4 years old. And the reason for that is that, back issues like herniated discs or, things like that, they can get better on their own. It's not necessarily common, but I've seen cases where somebody has a herniated disc and because of, whether it's stretching or other kind of therapy, the disc, kind of goes back in, or a bulging disc goes back in and is no longer symptomatic. So I think it's probably worth trying to figure out a way to come up with the money to get an MRI. And again, look in your community for the low-cost MRI clinics. Since my wife will be collecting more than I make on this, well, go mouse. I don't know. That's a very good question, Mike. I don't know enough about retirement Social Security to offer an opinion about that. Unfortunately, I don't know. There are people out there who deal with retirement Social Security that know a heck of a lot more than I do. I just don't know. And I think that's maybe an accountant would be a good place to start. I just don't know. Okay, so the I asked about the spinal cord stem. You said you get some result with the neuropathies there. Well, I'm glad that you get some result from it because again, I know some people have a real problem with it. I've had several cases with the machine, the stem machines that are put in go bad. They've been recalled, and then it's really hard to get them out, and then the leads go bad. I mean, it can be a mess. So if you're getting good results, that's a good thing. By no means a guarantee. Shane, my pleasure. Do they call for new hearing after you've been in disability free? No, they do not. They basically would. The only thing they would do is they might do a review, and then if they move to terminate, which I don't think will happen given your age, then you could go to another hearing. But they don't do a redetermination automatically unless there's something that suggests you were able to work. I'm going to pain management tomorrow. They want to do a nerve ablation on my neck, 5 herniated discs. I think he's asking the group. My experience observing nerve ablations is they work for a short period of time and then the nerve grows back. It may give you temporary relief, and I don't see it as a cure. That's just my observation here. Let's see here. I want to thank you for answering my question. Sure, my pleasure. That's why I do these. Andrea, not finding access to the forms library. See if I can video, but need a link, please. Okay, Andrea, I will get you that link tomorrow. Yeah, I put it on Vimeo. So Andrea needs link to forms library. Yeah, it's on Vimeo, so it's not on YouTube. Vimeo is another video hosting platform that is private, so I just make it available to my clients. So that's why, but it should be, the link should be there. I'll check there's an email that's got it in there, but I'll make sure you get that tomorrow. Now, trigger point injections are different than a nerve ablation. A nerve ablation is where they actually burn the nerve. A trigger point is they put like an anesthetic in certain trigger points that can help. And they're both, pain management techniques. Melissa Ruthven, in my 5th year fighting tooth and nail. Disabilities are overlooked. Doctors say what they want. They don't feel my pain. I hear you. I mean, chronic pain can be a very, very difficult thing to quantify. It can be hard to prove you've got it, especially if there's no objective test. I've had people with fibromyalgia. They've had people with RSD, all these different chronic pain conditions that are very real, but hard to prove. Social Security really relies on objective testing like MRIs or CTs, and when you don't have those, it's more of an uphill battle, no question. Ticket to work. Rebecca's asking about ticket to work. I know nothing about the ticket to work. I've not heard any, really, I don't hear much about it at all. Nobody really talks about it. So I don't know. Again, maybe that's something that we can ask Andrew Sendler next week. I just don't know enough about it to say. I just don't, like I said, I hear so little about it that it has value or not. I just can't really say. That may be a question that Greg, the Disability Yoda, I don't know why, I just blank on his last name for some reason. This drives me crazy. Some people, you ever had that happen? Greg Brinkley. Okay. Greg, you might want to check with Greg Brinkley and his, it's greg@gregbrinkley.org is his email. He might have an answer to that about the ticket to work. He might know. So that would be somebody to talk to about that. And let him know I suggested you call him. Thank you, Christine. Yes, press the like button. Very much appreciate that. John is new to my channel. Been getting epidurals for 3 years. They're not working. Need to have surgery. Doctors increase your pain medication. Now I'm falling asleep on the verge of losing my job in logging. 25 years, turning 62. I always tell people if you can work, you should try to work because you're going to make more money, be happier. But, if you're doing something as dangerous as logging and you're falling asleep, you got to really wonder if it makes sense to keep doing that. I think you probably have a pretty good case given your age and given the nature of, your past work. You're not going to be transferable skills. I think that, you probably meet the grids. So I think you've got a winning case. You've got a surgical recommendation. Will it be approved in 6 months or is it going to be 2 years? That I can't tell you, but I think you've got a good case based on what you're telling me there. Oh, found it. Okay. Yeah. You find the factor request form. Very good. Okay. Yeah. Cause like I said, it's on Vimeo and you should have access to the videos as my client. Okay. Mary. Yeah. If you're, I think you have to put your foot down. Like, I don't want to do this because I'm really concerned about infection. And, they may choose to say they may terminate your relationship with them. They may say you're being non-cooperative, but Social Security won't hold it against you. And they may limit what they can do for you. But, if you don't feel comfortable, do it. Don't do it. Okay. All right. We got about 10 more minutes to go here. Okay. Well, she's downstairs right now. I showed my wife on video. She's downstairs waiting for me patiently to finish up here. She does workers' comp in Georgia. So I don't know that she wants to come on, but I'll ask her. Maybe she'll make an appearance at some point. Thank you, Nickerson. I will definitely reach out to you tomorrow. These are facet joint injections, medial bone joint. Okay. So yeah, it'll give you short-term relief is my experience as well. That's okay, Christina, not a problem. You are very welcome, Shane. Thank you. Yeah, sometimes, when you put something online, it just never goes away. All right, Edward, you got it. You got me here. Can I do a rib dib CT? Don't have any idea what that means. Perhaps you could explain it. What is a rib dib CT? Okay, very much. Thank you, Christina. Absolutely. Got to prove. Don't do the August the 18th after 3.5 years. I'm not sure what that means. Is back laminectomy surgery? Well, you don't win because of your surgery, but it does suggest a problem. So I think that absolutely a laminectomy would be indicative of a problem because it's back surgery. They don't do back surgery unless there is a real reason for it. So let's see here. Wrong one here. Okay, Instagram there, and let me put. I got too many of these little banners here, so let's try again here. There we go. Okay. Let's see. Okay, Edward has back. Yeah, I mean, again, that doesn't qualify you on its own, but it does suggest there's a problem. So you need medical records that, discuss your functional capacity. The neurologist guessed it was scar tissue causing pain. If my MRI doesn't show anything clear, so my doctor is to guess I was that bad, but with pain doc and med meds for years. I mean, if I look at medical records, the doctor says, I don't know what's causing her pain. We think it's scar tissue. That's not a real definitive diagnosis. I mean, it would be much more helpful to know something specifically that's causing your pain. Scar tissue is a logical thing. Narrowing is logical, but if the MRI doesn't show it, then you're asking the judge to award disability based on something that somebody is guessing that there's no objective evidence from. That's hard. That's hard. Yep, I agree with Jeff. I agree with that. You have the Boswell Scientific. Again, there's different ones, and what I would do is I would look up the model and see if there's been recalls, see if there's any problems, because get ahead of that if you can. You don't want to wait until there's a problem and then have them have to remove it. Okay, so Jeff has had nerve ablations. Yeah, it's temporary. I agree with Jeff. My script gets rid of migraines, but they're frequent, loud, constant noise for urination meds. Yeah, that makes your case. Being 61 helps. The frequent urination helps. If you have lupus and neuropathy, you could be, absolutely. And I think it's 53 is better than 43, not as good as 57 or 55. But I think if you have strong medical support, you can definitely win. Absolutely. Okay. Bill touch these, but just at home, back fail. That's a medical. I can't really, without looking at the medical evidence, I can't really say. That's a medical determination essay. Okay, so you're getting ongoing treatment. So, yeah, I mean, I think that's going to tell me that there's not likely to be a review. Okay, I talked about this before. If you work part-time, you can, but you want to keep your earnings. Be aware if you want to use up your trial work period months, I think it's $1,160 a month. If you're trying to stay below SGA, that's $1,620. So definitely stay below SGA. Thank you very much. We have a few more days, but yeah, that would be great. I'm having a good time here. Retirement, even though my wife gives me the stink eye when I eat Oreo cookies and pizza, but that's the way it goes. Retirement and SSI at the same time. Okay, so you're asking me, Edward, can I do retirement disability? You don't get both. You get the higher of the two. So, okay. SSD attorneys email here. It's SSD answers 123@gmail is my email if you want to email me. SSD answers 123@gmail.com. Hey, Rock, how you doing? Indentations of the fecal sac. Again, that suggests something serious. Thank you. Appreciate that, Rock. And thank you very much, Mike. Appreciate that. Person manning the questions, someone writing stuff down. Yeah, I mean, it's not that hard to do. I use a program called StreamYard, and so I see the comments coming up from both Facebook and Instagram and LinkedIn. They all come up on the side. So I have a little. You click on something and it pops up here. So pretty easy to do. It's amazing that you can do. Basically having a live TV show. Think about 20, 30 years ago. So doing this every week. Basically almost no cost. It's amazing. The reason I took recon, my reverse office in Atlanta, yeah, Atlanta, you probably got the Stone Mountain office. Hearing, if once you request a hearing, 5, 6, 7 months. But yeah, there's some Stone Mountain office is really bad here. Got to talk to Angela. Yes, Angela's great. She's really doing a good job. Okay, good deal, RD. We'll see you next week. And good. I'll let her know. She's got a fan. Okay. All right. We'll leave it at that. I got one more question from Rock. Rock said so many nice things about me. I got to answer his question. If you have to apply for SSI, you can't just, it's not automatic. So, if you have an SSI, if you have the limited income and assets, then you would apply for SSI. So we would want to make sure that you are applying for the right programs, because if you have a household income or assets, you wouldn't even want to apply for SSI. The grid rule, look at gridrules.net. Look at gridrules.net. Okay, we're going to end it at that. And I think Christina has been very, very nice to suggest to everybody that they everybody have a good evening, and to you got it, Rock. Thank you very much. And just leave me a review if you find this helpful. And if I could be of assistance to you, let me just put this banner up here one more time. Get a case evaluation, just reach out to me here. So I appreciate everybody's attendance. I'll be back in my home base next week, and hope everybody has a great week. And I will hopefully have a rest of my vacation. We'll have good weather, and hope the weather's good where you are too. We will talk to you next week. Thanks, everybody. Bye-bye.